Hello, my name is Victoria Ortiz, and I will be doing my oral presentation on Miller versus California. So in the case of Miller versus California, the main reason why the case came about was because Miller had distributed obscene material back in 1973, and the obscene material was in the form of a brochure that was mailed out to different homes and businesses across California. The main argument is whether the state was infringing on Marvin Miller's First Amendment right by taking him to court over his distribution of obscene material to the residents in California. Some of the important facts here that we should take into account is that he did in fact mail brochures that contained sexually explicit activities to individuals who had not requested the material to be sent to them, and they did not give consent. And so therefore, since they did not consent to the material being sent to them, the individuals who were offended by him sending them this brochure they did notify the police. He had assembled a brochure that advertised books and movies, more specifically books, Intercourse, Man, Woman, Sex Orgies Illustrated, and an illustrated history of pornography. And the main movie that he advertised on this brochure was Marital Intercourse. He did in fact mass mail the brochures, and 5 of the unsolicited brochures had reached to a restaurant in Newport Beach, California, which is where most of the awareness came about this brochure. But also there was a family, a married couple who had received one at their home, and therefore they made a police report as well. Some questions to consider about the case. The first question being, what is the criteria for the Miller test? The Miller test is what came about the entire case, as there wasn't necessarily a way to determine if the material was considered to be obscene or not. So therefore, after this case, they came up with the Miller test that tested obscene material to see if it's chargeable, basically. The answer to this is that the test included the following criteria. Number 1 being that whether the average person applying contemporary community standards would find that the work, taken as a whole, of course, appeals to prurient interest. Number 2 is whether the work depicts or describes in a patently offensive way sexual content specifically defined by the applicable state law. The last one, number 3, being whether the work was taken as a whole, or as taken as a whole, lacks serious literary, artistic, political, or scientific value. So he sent this brochure, of course, advertising some books and also a movie. However, it never had any serious matter in it. Therefore, it was just inappropriate content being sent to people that weren't going to take it seriously the way he saw it as serious. The second question being, does the First Amendment protect obscene material? The answer, the First Amendment does not protect obscene material. Obscene material is not protected due to its sexually explicit content violating community standards and has no serious purpose at all. Now, the third question is, what is the difference between obscenity and pornography? The answer is that obscenity refers to a narrow category of pornography that violates contemporary community standards and has no serious literary, artistic, political, or scientific value. For adults, at least, most pornography, material of a sexual nature that arouses many readers and viewers, receives constitutional protection. The ruling in this case came down to a 5-4 vote, and Miller was convicted of violating the law by knowingly distributing obscene matter. It established the Miller test, like I mentioned before, for obscenity, as obscene material will not be protected by the First Amendment. In my opinion, I did not agree with Miller's statement of saying that they had gone against his First Amendment right. No one asked for the material nor consented. So because they didn't, they shouldn't have received the sexually explicit material. And especially I also thought about the family that had received it and wondering if they had small children. And sometimes parents do send their kids out to get the mail. So had they sent one of their kids out to get the mail, the kids would have seen it, and it would have been a lot worse because they would have been exploited to something that they weren't ready for. The significance to communication for this case, the court can now define the standards of what is considered obscene material without infringing on people's First Amendment rights by using the Miller test. And it is actually now applicable to other states via the 14th Amendment. All right, that is the end of my project, and I hope you enjoyed. Thank you so much.